Hello. Hello everyone. My name is Kanesh. Can I welcome you to this course of legal reasoning, basic to advanced. Through this course, what I think of delivering and the beliefs that I plan to instill in your minds, they are very clear. They are something that you will require when you are attempting the sections in all the law entrance tests or law entrance exams. When we talk about different institutions, I have seen that there is an idea, there is an entire belief that has been instilled into every student or everyone that is preparing for such examinations, that all these tests or all these sections of legal reasoning require a prior knowledge of law. Through this series, through this course, I would like to instill a belief that there is no prior legal knowledge required as such. If a person is a reader, if he reads, if he keeps on reading, if he has an eye or if he has an interest for law, and he is well versed with what's happening in the current legal scenario, then he or she can attempt such sections and not only attempt them, but rather ace them. What we'll be doing is we'll be starting our course by solving the questions of the papers that have happened to the date. We'll start with legal reasoning that was provided in the paper of CLAT 2020. By solving these papers, we'll understand how the questions are framed, what are the requirements of the consortium, and how we should go about these questions and what are the things that we must keep in mind. Without wasting any more time in introduction to the session and introduction to the course, let us dive into the questions and start solving. The very first question of legal reasoning from the CLAT 2020 paper starts this way. The COVID-19 pandemic has taken the entire world hostage. In less than 4 months, and the global economy has been hit the hardest, with governments across the globe implementing stringent policies, including lockdown, to control the coronavirus outbreak. The pandemic today presents unprecedented challenges and impediments to business in conducting their normal operation. Till this point, till the second sentence, we have yet not found anything consequential that would help us or aid us in solving the questions. But we get a fair idea that it's going to be about something related to businesses that are not operating so smoothly as they were, as they are being hit by the coronavirus wave. Let's move ahead. The lockdown across the world has caused delays in the performance of contracts and transactions. Now, the question that arises is whether the current situation can enable parties to a contract to alter their obligations with non-compliance of terms, neither being regarded as default committed by any party nor as breach of contract. Now it is in this particular part of the passage we realize that the passage is going to be about contract, or more specifically, the dishonoring of contract or non-fulfillment of contract. The passage here goes on to say that what will happen if in situations like those of COVID-19, parties chose to alter their obligations with non-compliance of terms, which basically means there were certain terms that were agreed upon by the parties, but now in the light of such issues like COVID-19, which were unprecedented or which were what we call something that was not predictable, can parties alter the obligations? Can parties change what they wanted to do and turn it from default committed by contract or breach committed to contract to something that is not, you know, something that is not breach or something that is not default? Can, by changing of such terms, will they enter into it or will they not? Let's move ahead and find out what the passage says. There are certain well accepted practices for dealing with such extraordinary situations in commercial transactions by the inclusion of force majeure and material adverse effect clauses. So now we are sure that the passage is going to be about contracts, and more specifically, it's going to be about the force majeure and material adverse effect clauses. Now, we don't know what both of these are. Let's wait for the passage to introduce what's the meaning of force majeure clause or MAE clause. Determination of types of circumstances so covered by force majeure clause contained in a contract is essential. Provisions of force majeure often cover natural disasters like hurricane, floods, and earthquakes as act of God. Other covered events may include a war, terrorism, civil disorder, fire, disease, medical epidemic, or by reasons of applicable laws or regulations. So here they have told that these clauses of force majeure, they often include these kind of instances, these kind of happenings or events. We can underline it before we move ahead. And we must focus upon the word that they may include. They may not. Let's move ahead. Broadly, the courts have interpreted the force majeure as an event that can neither be anticipated nor controlled by either of the contracting parties. So here we find what is the meaning of the force majeure clause. A force majeure clause applies in the context of ongoing contractual agreements, whereas an MAE or material adverse change applies to the allocation of risk in transactions before their closure or completion. Fair. So we now have an idea of when a force majeure clause or when a MAE or MAC clause is applied. Pandemic are related consequences such as government action. Pandemic and related consequences such as government action is a type of event covered by a force majeure clause. However, its impact on the affected party's ability to perform its contractual obligations may vary depending upon the contractual terms. So here in this particular part, we become aware of the fact that all these obligations that are entered into by the parties through a contract, they may be hindered through any of the events that were earlier mentioned, like a hurricane, a disaster, terrorism, or for that matter, coronavirus. Now, how it affects the parties and their ability to perform is to be specifically mentioned in contractual terms. Now we know that contracts may vary. A contract between a person A and B may vary to what person B has with C. Okay, so let's move ahead. It is common for force majeure clause to specify the impact that the event or circumstances in the question must have in order for the clause to be triggered. So now it is talking about the construction of the clause, how the clause must be. Moving ahead, references may be made, for example, to the event or circumstances having prevented, hindered, or delayed performance. Okay, so again, it is talking about construction. These terms require different levels of impact on performance before a party can claim recourse to these clauses. Fair? In other words, the force majeure and MAC clauses act as an exception to what would otherwise be treated as a breach of contract, which is fair, which is a basic definition. They are here saying that uh, if a force majeure clause is not applied or an MAC clause is not applied, and if the conditions are not of an exceptional nature, these clauses would basically act as a savior. They would save the parties from what would otherwise, if the conditions are normal, be called a breach of contract. Certain contracts may state that if a force majeure clause is applied, the contract may automatically be terminated. On the other hand, some contracts may even state that if the duty to fulfill the contractual obligation may be suspended for a certain period of time. And if the force majeure event is not curbed or treated even after such time, then eventually the contract may be terminated. Now, it is telling us how these particular clauses or how these particular conditions, when taken into account or when triggered, work. But the important thing that we need to take care of while we solve questions like these is that nothing of this sorts can be taken as or can be understood. Nothing of this sort can be taken as or be understood in its entirety to be applied on all the contracts. Here, we need to take into account the very fact that, on the other hand, some contracts, we need to understand these keywords, or at points, what we'll end up doing is we'll consider these statements to be applicable to all contracts, which is not the case. Moving ahead, on the other hand, some contracts may even state that the duty to fulfill the contractual obligations may be suspended for a certain period of time, and if the force majeure event is not curbed or treated even after such time, then eventually the contract may be terminated. Though there cannot be a one size fits all solution to this question, and it depends upon how the force majeure clause is worded in a specific contract, and in the absence of same, applicable laws related to the same will be required to be taken into consideration. This particular line here tells us about absence of any such clause or absence of a particular rule, regulation, or obligation that was to be a part of the contract but was left out by the parties to the contract. Now, if we zoom out and see what are the important parts in this passage, we can see that there are only some key sentences, and moreover, in the ending of it, towards the end, there are some key words that we need to take into consideration. Now that we have understood and we have a basic understanding of what a MAE or a force majeure clause is, let's move towards the questions and see how will these bytes or knowledge bytes of law help us solve these questions. The first question goes on to state that, based on author's argument in the sorry, there was some technical issue. So yes, based on author's argument in the passage above, which of the following is correct? Let's see. The impact of the performance of contracts by the usage of force majeure clause is dependent upon the way such clauses have been constructed in a particular contract. fair. The option says the impact of the performance of contracts by the usage of force majeure clause is dependent upon the way such clauses have been constructed, which is a good thing. He has not generalized anything, rather, the option leaves it upon the construction of the contracts to decide what the parties will do. Both force majeure and material adverse change clause have similar impact on performance of contracts. Nothing such was told to us. It might and might not. So, option B is the safest and the most accurate option that we'll go ahead with. Coming to the second question, imagine there is a domestic commercial contract for supply of certain goods for certain price between A and B. However, in pursuance of the same, both A and B forget to negotiate and agree on terms of force majeure event, and contractual documents does not contain the force majeure clause. In such a situation, what would be the fate of contract in the events like that of COVID-19? Now, this particular question again takes me towards the end of the passage, where it was said that applicable laws related to the same will be required to be taken into consideration when there is a gap or when the contracting parties have not decided upon the force majeure clause. So the law that governs contracts in India is the Indian Contract Act 1872. So in the three options, we will take option number 3 and we'll choose it as the correct now, with a modification that there is a force majeure clause in the contract between A and B. Let us suppose that B, who was to supply goods to A on certain date and time, faced issues in relation to procurement of goods due to mill strike and also because of rise in prices of goods. In this case, can B claim the suspension of performance of contract on the basis of force majeure clause? Now, throwing light upon the entire idea of a force majeure clause, as we have understood from the passage, I would like to recall the fact that force majeure clause is for situations that cannot be predicted or judged beforehand and basically hinder the fulfillment of contractual obligations. Taking into account what is the matter in this particular question, there has been a mill strike and there are rise in prices of goods. Both these conditions, looking through the lens of a reasonable prudent man, both these conditions are conditions that can be predicted beforehand by any reasonable individual. So, as a first hand opinion, I think that this cannot be considered a condition for force majeure clause. Let's use the options and see what is the most appropriate option in such a situation. Option A goes on to state that yes, B can, depending upon the way the force majeure clause is worded. Fair. It is very, what I would like to say, interesting option as it draws your attention. But let's read other options. Such situation cannot be covered under force majeure as it is just a case of disappointed expectations and hence B cannot invoke the clause. It is merely a case of commercial hardship. This particular scenario seems to be a more balanced one a more reasonable one. Let's go towards C. B can invoke the force majeure clause if the clause is too broad to cover such situations. Neither we have been informed of the construction of the clause between the construction of the clause in the contract that is signed between A and B. So, looking at it through a reasonable perspective and taking into account the conditions that were provided to us in the passage, B will be the option that we'll choose. Let's move ahead. Typically, the material adverse change provision in an agreement contemplates events which, if they occur or are likely to occur, would have a materially adverse change or effect on the assets, business, property, liabilities, financial condition, results, operation of the target, or that affects the ability of the transacting parties to consummate the transaction. Fair? Or the validity or in the transacting parties to its rights and remedies under the transaction documents. Which of the following sample clauses in the contract resembles an MAE clause? In the event either party is unable to perform its obligations under the terms of this agreement because of act of God, strikes, equipment of transmission failure, or damage reasonably beyond its control, such party shall not be liable for damages to the other party for any damages resulting from such failure to perform. Now, basically, MAE goes on to state that it is an agreement, MAE clause in an agreement contemplates events that, if they occur, will or are likely to cause materially adverse change or effect on assets, businesses, property, liability, financial conditions resulting in operation of the target. But here if we see act of God fits, equipment or transmission failure is also fine, but strikes would not take place or would not be a part of MAE or any force majeure clause because of it being a very normal or predictable thing. Because here we are talking about unpredictable things that would lead to such situations of non-performance. Option B states that except with respect to payment obligation under this agreement. The very first line goes and states that except with respect to payment obligations. So applying this into the real world, it would mean that anything is fine, everything can be stopped or can be taken away from the liability of a breach of contract, but the payment obligations are to be fulfilled. So this too cannot be taken into account as it is not reasonable or logical. We'll go ahead with option D. We have finished one passage. Let's move on to the second passage of the day. Probably the last one. The issue of obscenity. The issue of obscenity has vexed the courts in India and abroad for a long time now. The intriguing question has always been the same. What should be the standards to qualify something as obscene in the eyes of law? Till this particular sentence, till this particular sentence, what we or I in particular have gathered is that this passage will be talking about obscenity, and then there might be a comparative thing, there might be a comparative analysis between the laws of India or somewhere else. Let's proceed and see how or what does this passage hold. In the United Kingdom, way back in 1868, the court laid down Hicklin test in Regina versus Hicklin and held that. So now the author is going to talk about a test. Now, these are some questions that you might find very interesting, as they'll give you a set of standards that you might have to verify upon conditions that will be provided in questions later on. Not only this, but there might be multiple tests at times. Let's move ahead and see what are the requirements of this particular test. The test of obscenity is whether the tendency of the matter charged as obscenity is to deprave and corrupt those whose minds are open to such immoral influences and to whose hands a publication of this sort may fall. So neither did I knew what is Hicklin test, nor did anyone else. But now the passage has sufficiently explained us what is the Hicklin test. Hicklin test postulates that a publication has to be judged for obscenity based on isolated passages of a work, considered out of context and judged by their apparent influence on most susceptible readers, such as children or weak-minded adults. So, in the earlier part, or in the now, how is Hicklin test conducted is later explained in the passage, stating that the publication has to be judged for obscenity based on isolated passages of work considered out of context and by their apparent influence on most susceptible readers, such as children or weak-minded adults. What we gather from this particular line is that any publication, any material that is published or that is consumed by any type of that publication of obscenity, that publication of some obscene content will not be related to the context of the entire publication or the entire movie or the entire post, considered in an isolated manner. You need to understand this part. It will be considered far away from what it was intended to portray, far away from in what sense it has been used. Only the obscene material or the material in question will be tested, not what it was meant for, okay, not how it was meant for to be consumed, and neither the impact, not the impact, neither what it meant to convey. So this is the Hicklin test. Let's move ahead. However, this test was later rejected by most of the jurisdictions. Passage has informed us that this test. Sorry for the delay. There was some technical issue. Yeah. So we have studied what the Hicklin test is in the passage. Now, the obscenity, the idea of obscenity that was discussed in Hicklin test was an idea of isolation. But now the author goes on to say that obscenity has to be considered in tandem or in accordance to the socio-moral attitude of the community. Something in 100 years ago, but can that be considered obscene now? That is to be that is to be answered. That is to be understood. Looking at how the society currently is functioning, what is acceptable, what is not acceptable. These judgments indicate that the concept of obscenity would change with the passage of time, and what might have been obscene at one point of time would not be considered as obscene at a later period. This is something that we were just talking about. This came to be known as community standards test. Okay, so now the author has provided a name to it. Now this is called the community standards test. In Bobby Art International and others versus Om Pal Singh Hoon, the court upholding the community standards test held that complete message and context of objectionable scene, film, picture, etc. needs to be examined in order to find out whether the alleged material is obscene or not. Both these tests, one being the Hicklin test as discussed above, and second being the community standard test, both these tests are on the different ends of spectrum. The Hicklin test considers the entire objectionable material or the material in question in terms of isolation. There is no context that is taken into account or judged with the material in question, but rather the community standard test takes into account what is happening in the community, takes into account the entire context in what the applied the questions and